being broadcast as a live stream over the internet, which means that any member of the public can now log on and watch this proceeding. To all defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. I believe I have been alerted to some outstanding issues, but I believe the calendar is correct. If not, we can discuss further at a later point. Who do we have first in courtroom 2?
Yeah, position number 1, Mr. Ailes.
Position number 1, you said?
Yes, ma'am.
Thank you. Good afternoon. Are you Quentin Ailes or Isles?
Yeah, ma'am.
Okay. Your case is 22 CR 000-346A, in which you're charged with 1 count of simple battery. You've heard me advise you of your right to remain silent. You also have a right to an attorney today at this proceeding. Who represents this defendant?
I do, Your Honor. Good afternoon.
Good afternoon, Ms. McLeod. Good to see you. As you can see, your attorney and I are both appearing by video. Mr. Ailes, do you object to a video hearing today?
No, ma'am.
Or do your attorney assisting you remotely?
No, Your Honor.
Thank you. All right, at this time I see Mr. Howard that he is recommended. Can I have the history, please?
Who are we on?
Position 1.
Ailes. Okay. First arrest.
Okay,
That's what I have.
thank you. And is this your case, Ms. Arnold?
Yes, Your Honor. Good afternoon.
Good to see you, Ms. Arnold. What is the state's recommendation for his bond?
The state is recommending a $2,000 surety bond, that there be no further contact with Kiana Ailes. Kiana spelled Kionna, Ailes spelled Ailes, that there be a stay away from 808 Alois Court Southeast, Alois spelled Eloise, apartment C, in Atlanta, and a 1-day anger awareness, no drugs, alcohol, or weapons. Your Honor, this incident happened on December 31st, 2021 at that Alois Court location. Ms. Ailes advised that she was helping her brother, the defendant in this case, by letting him stay at her apartment until he got back on his feet. When Ms. Ailes asked the defendant to simply clean up behind himself, he got angry and started an argument. At some point, the defendant's girlfriend started calling Ms. Ailes the B word and other names. And then at some point after, the defendant pushed Ms. Ailes toward the couch, pinned her down, and started choking her. When Ms. Ailes yelled that she would call the police, that's when the defendant got off of her and left the location. Your Honor, based on the facts of this case, we are requesting the $2,000 surety bond with the conditions as stated. Thank you.
Thank you. Ms. McLeod?
Yes, Your Honor. Mr. Ailes is 21 years old. This incident, as the prosecutor said, happened with his sister, but it didn't happen as the prosecutor alleges. What happened was that Mr. Ailes' girlfriend and his sister had an argument, and he got in between them to separate them. Right now, his sister has been arrested, and she has asked him to move back into the house to babysit her daughter for her until she's able to get out of jail. And that was her request recently. So he's actually now back there. He had in fact moved and was living with their mom. My client doesn't have any criminal history, Your Honor. This is his first arrest. I think he's a good candidate for a signature bond. He lives here in the Metro Atlanta area. He is gainfully employed, and he's not a flight risk at all.
All right, thank you, Ms. McLeod. At this time, Mr. Ailes is going to receive a $4,000 signature bond through pretrial services. He is to complete the 1-day anger awareness course. He is to have no further contact with the victim, Kiana Ailes. As a condition of this bond, he must also stay away from the address on Alois Court. He is to have no alcohol, drugs, or weapons. And I did say the 1-day anger awareness. I am going to require that at this time.
Yes, Your Honor.
Go ahead,
Yes,
Ms.
Your
McLeod.
Honor. He's actually babysitting her child. He was babysitting her child before he got picked up, and she is apparently still arrested.
Okay, I understand that, but he still needs to stay away from her. If he's gonna assist with watching the child, he'll need to arrange that through a third party at this time as a condition of this signature bond. All
Thank
right,
you.
all right. All right, Mr. Isles, best of luck to you. We will now move to the next position. Who do we have next?
Yeah, number 3, Mr. Donaldson.
All right, good afternoon. Are you Martin Donaldson?
Yes.
Okay, Mr. Donaldson, your case is 22 CR 000348J, in which you're charged with simple battery, 1 count, with an offense date of October the 5th of 2021. I want to advise you again, you have a right to remain silent and you have a right to an attorney at this proceeding. Who represents Mr. Donaldson? Does he have an attorney present on the screen? Mr. Donaldson, are you aware whether or not you have counsel? Or is it Ms. Gant? Is that you?
Yes, Your Honor, I do apologize. I represent Mr. Donaldson.
Thank you. As you can see, both your attorney and I are present on this screen, conducting this proceeding by video. Do you object to that today?
No, ma'am.
Thank you. Mr. Howard?
Second arrest. Last arrest was 2019, terrorist threats and harassment phone calls out of Dunwoody. I think that case was non-pros.
Okay. Thank you. Ms. Arnold, this is your case as well?
Yes, Your Honor.
All right, the state's recommendation?
Yes, Your Honor, the defendant currently has a bond of a $500 surety. The state is recommending a $3,000 signature bond with the conditions that there be no further contact with Michael Schroeder. Michael spelled traditionally, Schroeder spelled SCHRODER. We're also recommending that there be a stay away from 2345 Peachtree Road Northeast in Atlanta, a 1-day anger awareness, and no drugs, alcohol, or weapons. Your Honor, this incident happened on October 5th, 2021 at that Peachtree Road location. Here, the defendant spit on Mr. Schroeder, specifically in his face and on his clothing. The defendant only has 1 cycle, as pretrial mentioned, Your Honor. So because of that, we are recommending the $3,000 signature bond. Thank you.
Thank you. Ms. Gant, any objection?
No, Your Honor, I do not object to any of the conditions except the stay away order. Mr. Donaldson, I apologize, advised me that he picks prescriptions up from that pharmacy on a weekly basis.
That address is what is it, a CVS or a Walgreens or something?
It's a Walgreens pharmacy.
Okay, I am going to accept the state's recommendation, Ms. Gant, at this time. And what Mr. Donaldson will need to do is arrange to transfer it to another pharmacy. I believe that can be arranged. So I'm going to adopt the state's recommendation in its entirety. He'll receive the $3,000 signature bond through pretrial services. He is to stay away from that location and transfer his prescription to another pharmaceutical location. He needs to take that 1-day anger awareness course, and he needs to stay away from Martin Schroeder, have no weapons, drugs, or alcohol as a condition of his bond. All right.
Thank you, Your Honor.
Thank you.
Your
Best
Honor.
of luck to you, Mr. Donaldson. Who do we have next?
Yeah, positions number 5 and 6, Mr. Glover.
Okay.
Your Honor, if I may make an inquiry.
Yes, Ms. Falk.
Position Mr. Fernandez's case, it would be position 4. I just wanted to inquire whether the defendant is still in medical reset. He has been for a number of weeks now, and we normally have an interpreter come into the Zoom. And so if we can release that interpreter, if he's not going to be present, I would like to.
Okay. Is position 4 medical reset? Does anyone know?
Yes, he is, Your Honor.
Okay.
Is there an interpreter on the line? We did not request one today.
Okay, I didn't know because the interpreter had been coming pretty regularly, so I just wanted to double check.
Okay, I appreciate
Okay.
it. And just for the court's update, we are planning to interview him today, so hopefully we'll be able to address
Waive his
his case
appearance.
tomorrow.
Okay, that sounds good. Thank you, Ms. Gant, for that. If the interpreter just so happens to be on the line and is currently muted, you are now free to go. We will not require your assistance today. Are there any other positions that we're aware of, our medical resets at this time?
Your Honor, position 7, Kyrie Jones, I was awaiting a call from my client, but I have not heard anything at this point. As I understand it, this is a quarantine case, so unless I hear something from the jail regarding an opportunity to interview them, we will need to reset that case as well.
All right, thank you. All right, we'll go back to positions 5 and 6, Mr. Reginald Glover. Mr. Glover, you have 2 cases. Your first case is 22 CR 0000349A, in which you're charged with 1 count of criminal trespass with an offense date of August the 26th of 2021. In your second case, 22 CR 0000350A, you're charged with 1 count of battery against a pregnant female with an offense date of September the 10th of 2019. You've heard me advise you of your right to remain silent and your right to an attorney. Do you object to us conducting this by video today?
No, ma'am.
Thank you. And Ms. Gant, do you represent Mr. Glover as well?
Yes, Your Honor.
Thank you. Do you object to Ms. Gant assisting you remotely? Mr. Glover, do you object to Ms. Gant, your attorney assisting you by video?
Yes.
You object to that?
Oh,
Or
no.
you don't?
No, I'm
You're
sorry.
okay with that? Okay,
Okay, I'm sorry.
no problem. All right, Mr. Howard, can I have his history, please? And we'll try to address both of those cases together if we can.
8 total. 8th arrest. Last was on the 24th of this month in Smyrna. Failed to appear for a suspended license. January 22nd, arrest out of Cobb for suspended license. December 2020, suspended license. February 2020, 2 counts of suspended license. 2019, suspended license. 2018, same thing. And another 2018 arrest for the same thing.
Okay, nothing violent, no FTAs.
All suspended license.
All right, thank you, Mr. Howard. Whose case is this for the state? Is it Ms. Falk or Ms. Arnold, or is it Mr. Long?
It's my case, Your Honor.
All
Good
right,
afternoon.
thank you. Good afternoon, Mr. Long. What is the state's recommendation?
First, I just wanted to clarify on the position 6 case, there is an added count 2, which is a family violence battery. And that was
Okay.
added on today.
Okay, yes, I see that. I apologize. There is an additional count, Mr. Glover. There's a battery family violence charge as well with that same offense date of September the 10th.
Okay. So for the position 5 case, that's SG 70663622 from August 26th of 2021. That is a criminal trespass against property with victim Shanique Walker. That's spelled SHA''NIQUE. Walker is common spelling. She is also the victim on position 6 as well. In the 2021 trespass case, the defendant smashed the rear window of Miss Walker's vehicle with a baseball bat at the location of 2591 Etheridge Drive Northwest. That's in Atlanta at the Rolling Bend Apartments. And that incident stemmed from an argument that they had about their 4 children in common. And in that case, the state's recommendation for bond will be a $2,500 surety, no further contact with Shanique Walker, 12-week anger management course, stay away from 2591 Etheridge Drive Northwest, which is the Rolling Bend Apartments. And then in position 6 from September 10th of 2019, it occurred at the same location as position 5, so 2591 Etheridge Drive Northwest, apartment B323, Atlanta, Georgia. In that case, there was a verbal argument between the defendant and Miss Walker after the defendant was angry that Miss Walker had left him in the apartment alone for an extended period with their 10-month-old twins. At the time, she was 8 months pregnant with their soon-to-be 3rd child. And in response to his anger, the defendant charged at Miss Walker, struck her in the mouth with a closed fist, slammed her on the living room floor, and kicked her in the stomach, ribs, and chest before dragging her across the room. Law enforcement noted that Ms. Walker had a visible laceration on her lip and had complained of face, jaw, ribs, and left forearm pain. In that case, the bond recommendation is $5,000 surety for count 1, $2,500 signature for count 2 as a split bond, total of $7,500 on that case. No further contact with Shanique Walker or their minor children. 12-week anger management course. Stay away from 2591 Etheridge Drive Northwest, Rolling Bend Apartments. So the total state recommendation is a split recommendation between the two cases, $7,500 surety, $2,500 signature on count 2 of the second case. The reason for the state's recommendation is we have had contact with Ms. Walker, and Ms. Walker has been somewhat vacillating about her desire for contact with the defendant. Initially, she did indicate that they do not live together. They now have 5 children in common. And she indicated that they had not had any violence since the 2021 trespass case, but she did say that they had been arguing a lot. And she did confirm that she was kicked in the stomach while pregnant in 2019, but did not tell the hospital about the assault. We had another conversation though with her, and she had indicated that she did not want any contact with the defendant. She did not want the defendant to have any contact with the children. And she indicated that the defendant and the defendant's girlfriend have been harassing her since the defendant has been arrested in jail. And she further was confirming the events from the 2019 case, including the punch to the face and again, the kick to the stomach. So in this case, Your Honor, the state has a concern that the defendant will reoffend. We have 2 different charges here. One is trespass, the other is battery. But these 2 separate incidents are both situations where arguments have been regarding their children in common, with the defendant reacting violently to those arguments. Pre-trial, I'm sorry, one second.
We've all been there, Mr. Long. We've all been there.
Pre-trial did mention that there was a failure to appear from Cobb County. We do believe the defendant is a potential danger to the children in the case because they do seem to be a trigger for his anger. In one case, having to watch the twins, in another case, also in regards to the children. And we do believe that he's a danger to Ms. Walker herself, in the first case using a weapon to facilitate his anger, and in the second case to violently attacking her and kicking her abdomen while she was 8 months pregnant with the child in the 2019 case. So for those reasons, we are recommending the total bond of $10,000, $7,500 surety, and $2,500 signature bond. Thank you.
All right, thank you, Mr. Long. Ms. Gant, but before I go to Ms. Gant, let me confirm the numbers again. You're asking for position 5, a $2,500 surety bond, and position 6, you're asking for a split $7,500, $2,500 on count 1, and $5,000 on count 2, correct?
So for position 5, that was correct. For position 6, $5,000 count 1 surety and $2,500 signature.
For the battery family violence, you were asking for the 6?
For count 2, it's $2,500 signature.
Okay. Just wanted to be clear. Thank you, Ms. Gant.
Thank you.
All right, thank you, Your Honor. Mr. Reginald Glover is 32 years old. He was born and raised in Atlanta. He has family here, therefore he has community ties, including 4 children. He denies having 5 children with Miss Shanique Walker. He is the proud father of 2 twin sons who are age 3. He also has a 2-year-old daughter and an 8-month-old as well. He also has an 11-year-old daughter from another relationship. He is actively involved in his children's lives. He provides financial and emotional support, financial when able, as he is unemployed and has been so for a year. However, he is actively seeking employment. Prior to becoming unemployed, he worked in the as a driver, and he also had many jobs working in a warehouse. At this time, Your Honor, we are unopposed to a stay-away order, as Mr. Glover indicates that he does not live at 2591 Etheridge Drive. We are unopposed to no contact, as Mr. Glover states that he has not been in contact with Ms. Walker. He does not want contact. However, we would request a third-party transfer. With regard to the allegations, as with regard to position 5, he disputes those allegations, Your Honor. He denies being the initial aggressor in that event. As the warrant states, Ms. Walker smashed the door into him. With regard to the second case, 22 CR 00350A, he denies those allegations outright. He denies making any physical contact with her whatsoever. Your Honor, based on my client's prior history of no violent convictions, and I do acknowledge that he has 2 open cases with the same victim. However, he is presumed innocent, Your Honor. He denies these allegations. He's unable to pay a high bond. So therefore, I am requesting a signature bond. And if Your Honor determines that he is ineligible, then he has no more than $200 to put toward all of the charges. We are unopposed to the $2,500 signature bond for battery family violence for position 6. We have spoken regarding our wishes for the stay away and no contact. And the last thing that I would add, Your Honor, is that we are opposed to a 12-week anger management program. My client has not been convicted of any crimes of violence at this time. And again, these are allegations, and I ask that you not consider the speculative arguments made by the state. Thank you.
Thank you, Ms. Scamp. All right, as to position number 5, Mr. Glover is going to receive a $2,500 signature bond through the jail. He is to have no further contact with the victim, last name Walker. He is to stay away from the address on Etheridge Drive. He is to have no weapons, drugs, or alcohol as a condition of that signature bond. As the case number position 6, case 22 CR 00 ending with 350A, he's going to receive a $2,000 surety bond on count 1 and a $2,000 surety bond on count 2. The same conditions apply: no weapons, drugs, or alcohol. He must stay away from that address on Etheridge Road, I believe, have no further contact with the victim, last name Walker. And if he wants to arrange to see his children, he'll need to do so through a third party.
All right, thank you, Your Honor.
Thank you.
All right, are there any other conditions? If not, best of luck to you, Mr. Glover, and we can go to the next position.
What was that bond amount again, man?
He's gonna get on position 5. I'm really bad at this. Position 5 is a $2,500 signature. On position 6, it's a total and cumulative $4,000 surety bond.
Okay. Next, we have position number 2, Ms. Austin.
All right, position 2. Are you Brianna Austin?
Yes, ma'am.
Okay, your case is 22 CR 000347F, and what you're charged with failure to signal or I can barely read this. Hold on. Duty of driver to stop at a hit and run, and failure to signal or change while you were changing the lane, each with offense dates of November the 11th of 2021. You've heard me advise you of your constitutional rights and your right to an attorney. Do you object to a video hearing today? Ms. Austin, do you object to a video hearing?
No, ma'am.
Thank you. Who represents Ms. Austin?
I do, Your Honor.
Okay, thank you, Ms. Gant. Mr. Howard, I see she's recommended. What is her history?
It's our first. That was
Okay.
recommended for SOB jail.
Okay, thank you. Ms. Arnold?
Yes, Your Honor. The state is recommending a $1,000 signature bond for count 1 for failure to signal a lane change or turn, and a $2,000 signature bond for count 2 for the hit and run, for a total of a $3,000 signature bond, Your Honor. We are also recommending no driving and that there be no drugs, alcohol, or weapons. Your Honor, this incident happened on November 11th on the I-20 westbound ramp to I-75/85 southbound in Atlanta. Here there was a collision involving 2 vehicles. One of the vehicles was a 2019 Nissan Sentra being driven by the defendant. When the defendant changed lanes, she swiped a 2017 Nissan Altima, which was being driven by Miss Brandy Fort. Brandy spelled Brandy, Fort spelled traditionally. Ms. Fort advised that the defendant quickly left the scene and never stopped, but she was able to get the tag number of the vehicle. When the responding officer ran the tag, it did come back as being registered to the defendant. The officer then contacted the defendant on December 16th, 2021, and she admitted that she was the driver involved in that collision, but that she never saw where the other vehicle went. She also advised that she did pull over, police came, and she filled out a police report. However, the defendant could not provide a case number at that time when she was speaking to the officer and told him that she would call him back. However, the officer made note that on December 27th, 2021, the defendant had yet to call him back, and he was not able to find any record of the 911 call from the defendant. So, Your Honor, based on the facts of the case, and because this is the defendant's first arrest, we are recommending the $3,000 signature bond with the conditions as stated. Thank you.
Okay. And tell me those conditions again, Ms. Arnold. I was listening to your facts and didn't get them all down.
Yes, Your Honor. The conditions were that there be no driving and no drugs, alcohol, or weapons.
Okay, thank you. Ms. Gant?
Your Honor, we are opposed to the no driving condition. Ms. Alston disputes the allegations. She states that she did in fact follow up with Officer Wakefield. She states that she left the voicemail with a case number and that he never returned her call. We are unopposed to the signature bonds for both counts. Ms. Alston is 27 years old. She has been in Georgia all of her life. She is the proud mother of 4 minor children, ages 4 and 6. She is the primary caretaker. She has completed some college. She is certified to practice as a nursing assistant. However, she is working at the post office as a mail office clerk. Therefore, she needs to be able to drive back and forth to work and also be able to drive to basically provide and care for the needs of her children. Your Honor, again, we are requesting that we consent to the signature bond, but are opposed to the condition of no driving. Thank you.
Thank you, Ms. Gant. At this time, Ms. Alston is going to receive the $3,000 signature bond as recommended by the state, $1,000 on count 1 and $2,000 on count 2. She is to have no weapons, drugs, or alcohol. She must complete a defensive driving class, but I will not require at this time that she not have, she is permitted to drive after completion of that course.
Thank you, Your Honor.
All right, is there anything further from either the state or the defense?
Nothing further, Your Honor.
All right, best of luck to you, Ms. Alston. We can move to the next position.
Add on one, Ms. Merlane.
All right, the one I don't have printed. All right, Ms. Lang, your case is 22 CR 00358J, in which you're charged with 1 count of criminal trespass. You've heard me advise you of your absolute right to remain silent and your right to, Ms. Falk, I see you coming on. Is there an additional charge? I don't have it printed. What is the additional charge?
No, there is not an additional charge. I'm going to be presenting the case.
Okay, thank you, Ms. Falk. You've heard me advise you of your right to remain silent and to an attorney. Do you object to a video hearing today?
No.
You do not. Who represents Ms. Merlane? Okay, Ms. Kim, you're muted.
Yes, this is Kim, actually. Yes, I do represent Ms. Merlane.
Okay, thank you. Mr. Howard, can I have her history, please? Do you have it?
I got it from Falk. She says her first arrest, but I just looked at the bond assessment. She was recommended. So
Okay. Thank you. Recommended for pretrial or recommended for the signature bond of the jail?
I mean, it's family violence, right? If it's family violence, I'll take it. Unless
It's criminal trespass.
Criminal trespass legally cannot be family violence, but it does involve intimate partners. So we are asking pretrial to
I'll take it.
handle this case.
Yeah.
Okay, understood. All right, Ms. Falk, the state's bond recommendation?
Yes, Your Honor. The state's bond recommendation on this is a $3,000 signature bond. We are asking for no further contact with Emmanuel Joseph and a stay away order from 8372 Roswell Road, Apartment L, Sandy Springs, Georgia. Mr. Joseph's first and last name are common spelling. This incident actually occurred last night at approximately 11:41 p.m. So due to that, we don't feel there has been sufficient cooling off period since this incident was less than 24 hours ago. And Mr. Joseph and Miss Merlane, the defendant, got into an argument about relationship issues. At that time, Miss Merlane grabbed glasses and plates and began throwing them across the room, actually breaking the window of the home. When police did speak to the defendant, she did admit to the throwing of the objects and stated she was upset and began to see red and just started throwing items around her. She stated she did not intentionally break the window and she did understand that what she did was wrong. So based on that, the state is asking for a signature bond, being that this is her first offense, but we are asking for the stay away and for the no further contact, because again, we do have concerns that Miss Merlane has an anger issue. We are also asking for 1 day anger awareness in order for her to address that problem. Thank you, Your Honor.
Thank you. Ms. Kim.
Yes, Your Honor. We do not object to stay away. I mean, we do not object to SOB signature bond and no contact, no violent contact. However, we strongly object to the stay away because that is her permanent residency. That's where she lives. She moved from New York 5 months ago, actually, to Sandy Springs to start her new employment at California Kitchen Pizza. And if she doesn't have that place, she has no other place, no alternative address that she can go to. And Mr. Emmanuel Joseph, who has been 1.5 years of boyfriend. They have a good relationship. This was only one incident. There was nobody who got hurt and things just kind of got a little bit heated up, but she is cooled down. And when I spoke with her today, she was very calm and I don't think that this will ever happen again. So please, we just want to object the stay away order, please.
Ms. Kim, are you aware whether or not the victim, courtroom 2, would you mind muting that just for a moment? Ms. Kim, are you aware whether or not the victim still resides at that address?
Yes, he does reside in that place. And I tried to contact him, but we could not get through.
Okay, because I'm going to sound for him. Is the victim present on the screen at this time? I don't believe I see that his name on here. Hearing that the victim does still reside at that location, I am gonna institute the, first of all, I'll go with the state's recommendation. She's gonna receive a $3,000 signature bond on this case. She is to have no further contact with the victim as a condition of this bond, and she is to stay away from that address on Roswell Road. She can return one time with a member of law enforcement to get any of her things. I'm not going to require that she does the anger awareness course, but she is to have no weapons, drugs, or alcohol as a condition of that bond. Is there anything further from either party at this time?
No, Your Honor, nothing. Well, one question, Your Honor, is that through pretrial or is that going to be through the jail?
Through pretrial services.
Thank you, Your Honor.
SOB through pretrial.
You said
All right.
3,000, right?
Yes. Yes. All right. Is there anything further? If not, best of luck to you, Ms. Merlane. And we can go to the next position.
Number 8, Mr. Orr.
Okay, good afternoon. Are you Dion Orr?
Yes.
Your case is 22 CR 000-352D, in which you're charged with failing to keep a proper lane and driving a vehicle by homicide in the second degree, a misdemeanor, each with offense dates of September the 6th of 2021. You've heard me advise you of your constitutional rights and your right to remain silent. Do you object to a video hearing today?
No.
Okay, whose case is this for the state? Oh, it's Mr. Long. Mr.
Yes,
Long,
ma'am.
what is state's recommendation?
The state's recommendation is $1,000 surety count 1, $10,000 surety count 2 for a total of $11,000 surety. No drugs or alcohol and no driving. This incident occurred at the South Fulton Parkway in Fairburn in Fulton County. And the defendant's vehicle went off the road into the median and struck and killed Thomas Moses, common spelling for both, who was a stranded motorist walking on the grassy median at the time. Defendant had indicated that he did not know what he had hit. He pulled off to the shoulder and did a series of U-turns and called 911. The defendant stated that he had been up since 5 a.m. and worked a 16-hour shift that day. Furrow marks were located traveling from the left lane onto the grassy median where the collision occurred, and the collision appeared to have occurred with the defendant's vehicle's headlight, and the pieces of the headlight were located in the median, the left lane, and the right lane. The basis of our recommendation is we do believe that there is the potential that Mr. Orr could reoffend. The defendant is currently on probation, I believe, for a theft charge, and he has criminal history going back to 1992. He also has traffic violation history going back to 1989, including 3 citations on different dates for failing to obey signs or traffic control devices, 5 citations for speeding, a seatbelt violation, a following too closely violation, driving on the wrong side of the road, driving too fast for conditions, serious commercial violations, and then a repeat Georgia serious commercial violations. These are all from different dates, different years. We also believe that he's potentially a flight risk. He has 6 prior failed to appears for some of those traffic violations. And based on the facts of the case, we do believe that the defendant is a danger to the community, as his conduct in this case, even if it was unintentional, was the inevitable result of the defendant's terrible driving habits, as evidenced by his driving record. This is not a situation where the decedent, Mr. Moses, did something to contribute to his death by walking on the side of the road. Mr. Moses was a stranded motorist, and this parkway has a very wide grassy median. This incident occurred because the defendant made a conscious decision to drive after a 16-hour shift, and his recklessness led to someone's death in this case. And so for those reasons, we are asking for an $11,000 surety bond. Thank you.
Thank you. Ms. Gant?
Your Honor, my research into Mr. Orr's history is quite different from the state. With regard to convictions back many years, according to my research, I have an improper lane change, October 25th, 1996, and a no proof of insurance, that's October 25th, 1996. Your Honor, that's 1996, that's many years ago. I do not have any history of any prior traffic offenses, and if pre-trial may clarify.
Mr. Howard, can you reconcile those 2 differences?
What's the question?
We have a stark different history for position A. What do you have as far as his driving history or history in general?
Was the state giving the driving history or the criminal history?
Well, criminal history. That's what I'm
But
saying.
no, I'm asking, is the driving history?
It seemed like it was a good mix. Go ahead. I'm sorry.
So state, let me ask you, the driving history you gave, was that strictly driving, or is that the driving history on the criminal history?
So I didn't go into detail on the driving or on the criminal history. I mainly was focusing on the driving history.
You pulled the driving. Okay. So I just have the criminal history. Last arrest was 2019 for shoplifting. I don't have any driving stuff on the criminal history.
Okay.
Like I normally would. So that stuff would be on the strictly driving and the KQ.
Okay, that's still helpful. All right, well, Ms. Gant, go ahead with what you had. You said you had a 1996 proof of no insurance.
And an improper lane change, and the status is open and Odyssey for both counts.
Okay. Mr. Long, tell me what you had again, as far as that driving history.
So I've got 3 citations for failing to obey signs or traffic control devices, 5 citations for speeding, a seatbelt violation, following too closely, driving wrong side of road, driving too fast for conditions, serious commercial violations, and then there was another one that said repeat Georgia serious commercial violations, and that's from GCIC. And
What years were those?
The
What year
first
was the last one, the following too closely, the speeding, what years?
the first one starts in 1989, the last one is in 2009.
Okay. All right. Okay, Ms. Gant.
All right, thank you, Your Honor. Mr. Dion Orr is 49 years old. He was born and raised in Atlanta. He has parents and siblings in this area, therefore he has community ties. He completed high school and also 1 year of college in the area of business management. Your Honor, Mr. Orr is gainfully employed at iSavvy Designs, which is an event company. It is a family-owned business and he is a warehouse driver. Therefore, we are opposed to any conditions that would restrict his driving. Your Honor, I'm requesting a signature bond on Mr. Dion Orr's behalf, primarily because of the fact that the citations cited are very remote. Mr. Orr disputes the, let me back up. The driving offenses are quite remote for the court to consider. Mr. Orr regrets the outcome of this accident. And I would remind the court, this is an accident. Therefore, I am requesting a signature bond. And if Your Honor determines that he is ineligible for a signature bond, then a bond amount of no more than $500. Again, we believe that, the state alluding to his theft, that's prejudicial and unrelated. And we basically heard a lot about things that happened over 10 years ago. And I would ask again that Your Honor consider my client's recent history, not impose any driving restrictions, and grant the signature bond, or in the alternative, a surety bond of no more than $500. Thank you.
Thank you. In Mr. Orr's case, for count 1, he's going to receive a $1,000 surety bond. He's going to receive a $9,000 surety bond on count 2 for a total of a $10,000 surety bond. He is to have no driving, weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party regarding this ruling?
No, Your Honor, thank you.
Thank you, Your Honor.
All right, best of luck to you, Mr. Orr. Who do we have next?
We have number 9, Mr. Seals.
Okay. Mr. Seals, your case is 22 CR 00353D, in which you're charged with 1 count of simple battery on August 3rd of 2021. You've heard me advise you of your right to remain silent and your right to an attorney. Do you object to a video hearing today?
No, ma'am.
And who represents Mr. Seals?
Good morning,
Thank you,
Your Honor.
Judge.
Attorney Thomas Reynolds with the Reynolds Law Group here on behalf of Mr. Seals.
Okay. Good afternoon, Mr. Reynolds. Do you object to Mr. Reynolds assisting you by video, Mr. Seals?
No, ma'am. I have 2 lawyers prior on the screen, Judy Cam and Tony Rim. I wasn't aware that my fiance had hired Mr. Reynolds. He can represent me though. I didn't know if Miss Judy was going to be present today.
Okay, Mr. Reynolds, it appears you've been selected. Who else was representing Mr. Seals? Is it
Judy
Ms.
Kim for Mr. Seals. Yes, Judge. I was hired a few days ago.
Okay, apparently, Mr. Seals has selected Mr. Reynolds to assist him with this. So I believe you're free to go at this time, but you're welcome to stay and continue to observe and reach back out to his girlfriend who retained you, or perhaps you two can clarify who will.
I'll talk to his friend who hired me. I'll let Mr. Reynolds handle this. He's capable, more than capable.
Right.
So,
All right.
yeah, Judge, if I may be excused.
Yes, have a great afternoon, Ms. Kim. Thank you.
Have a go.
You too.
All right, before we begin, Mr. Howard, I see he's recommended. What's the history? Is this his first arrest?
No,
Okay,
It's his third. They both come out of 2019, one in Mississippi, possession of marijuana in a motor vehicle, and speeding. The other arrest was 2019. That was here, sale of marijuana, felony, possession of a knife or a firearm during the commission, and possession of a Schedule 4 controlled substance. He got PTI for those.
Okay. Thank you. Whose case is this for the state? Oh, Ms. Mitchell. Good to see you, Ms. Mitchell. What is the state's recommendation?
Good to see you too, Your Honor. Our recommendation is going to be $1,000 surety bond, no further contact with the victim, Yassel, spelled Yassel, Pacheco Borges, spelled Pacheco Borges. A stay away from address 600 Garson Drive, Northeast, Atlanta, Georgia, a one-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, the victim, Mr. Pacheco Borges, he was a maintenance employee at the apartment complex Tuscan, and reported that a red Cadillac passed through the apartment complex gate following another vehicle. When the red Cadillac almost hit Mr. Pacheco Borges, he moved out of the way. The driver of that red Cadillac was defendant, and he got out of the car, yelled at our victim, and asked if he wants to get hit. The defendant then battered Mr. Pacheco Borges by pushing him and hitting him in the left shoulder. Your Honor, the basis of our recommendation of a surety bond versus the signature is the fact that this defendant completed pretrial intervention on his 2019 case involving possession of marijuana, possession of a firearm, and possession of Schedule 4 controlled substance, as pretrial has stated. So as I said, that's going to be the basis of our recommendation, Your Honor, $1,000 surety bond.
Okay, thank you. And what is the stay away address? That's the entire apartment complex?
Yes, Your Honor.
Okay. All right, thank you. Mr. Reynolds?
Your Honor, we have no objection to the stay away address or stay away from the individual. Our client doesn't know the individual other than that one instance where they met each other and has no intention of returning to that address or interacting with that individual again. He obviously has a completely different account of what occurred that day. He actually says that he was struck by the alleged victim here, even according to the prosecutor's own statements of fact. The allegation is that that the victim was, quote, pushed or touched on his shoulder, which we think is a indication as to the lack of the violence on our client's behalf. But probably more indicative is the fact that our client has no prior violent history. He's an honors student graduate from high school and college. He's gainfully employed here, actually owns his own business, a store, in which he has significant inventory and a retail location that they sell out of here in the Atlanta area. He's also a part owner of a restaurant here in the downtown Atlanta area called The Goods ATL. He's not a violent person whatsoever. His fiance is actually on the call with us watching, who he resides with here in the Atlanta area. And he's been here for approximately 3 to 5 years now. He also has other family members in the Atlanta area as well, including cousins and uncles on a significant family base here. Again, with him having no prior criminal or no prior violent history here, and also him having never missed a court hearing or FTA, as pretrial correctly mentioned, he did have a prior drug offense here in Atlanta that lasted for about a year before he had the pretrial diversion. He never missed a hearing date for that, Your Honor. I actually know his fiance's family personally. And based on the foregoing, his lack of risk of threat to anyone in the community, his prior history of never included any violent acts, we would ask that he be released on his own recognizance, which is in accordance with the ABA standards, unless it can be proved that he has a substantial risk of non-appearance or that there is a need for some other reason for him to be released other than for his own recognizance. Since he is no flight risk and since he is not a substantial risk of violence to himself or others, we believe this is a good candidate to be released on his own recognizance in connection with the ABA standard rules for pretrial release, referring specifically to ABA Rule 1051, which says, because the law favors the release of defendants pending determination of guilt or innocence, it should be presumed that the defendant is entitled to release on his own recognizance on a condition that no new offense be committed. This presumption may be overcome by finding that there is a substantial risk of non-appearance or a need for additional conditions. Again, here, there is no need for any additional conditions. This was a one-time incident where our client is presumed to be innocent of and has no prior violent acts and no prior instance of not complying with the court orders, and we'll be present with him along to make sure that he's here for every other hearing. For all the foregoing reasons, Your Honor, we would ask that he be released on his own recognizance.
And Your Honor, if I may, the state would like to clarify that the police report specifically says the defendant pushed our victim and then hit him. That's all, Your
Right.
Honor.
Thank you. I think I have enough information. Thank you. At this time, Mr. Seals is going to receive a $3,000 signature bond through pretrial services. He is to have no further contact with the victim, last name Chago Boyes, and he must stay away from the address previously given by the state. He is to have no weapons, drugs, or alcohol as a condition of this bond. He is to complete that one-day anger awareness course as well.
Thank you, Your Honor.
Is there anything further from either party regarding Mr. Seals' case?
No, Your Honor, thank you.
All right, Mr. Reynolds, you can be excused. Have a great afternoon and best of luck to you, Mr. Seals.
Thank you.
Thank you very much.
Thank you. What position do we have next?
Number 10, Mr. Snipes.
Okay, good afternoon, Mr. Snipes. Your case is 22 CR 0003548, and what you're charged with one count of criminal trespass with an offense date of January the 25th of 2022. You've heard me advise you of your right to remain silent and your right to an attorney. Who represents Mr. Snipes? Ms. McLeod, you represent Mr. Snipes? Or is it Ms. Gant? Who represents Mr. Snipes?
I believe it is McLeod.
Ms. McLeod, are you able to hear me? Do you represent Mr. Snipes?
I'm sorry, Your Honor, I was having difficulty hearing.
Yes. Do you represent Mr. Snipes?
I'm sorry, Your Honor, I'm having a little bit of difficulty hearing.
Okay. Do you represent Mr. Snipes today?
Yes, Your Honor, I do.
Thank you. Okay, Mr. Snipes, do you object to this video hearing or to your attorney assisting you by video?
No, Your Honor.
Thank you. Mr. Howard, can I have the history, please?
11 total. 2017 criminal damage to property, second degree. Aggravated stalking. Non-pros. 2017 simple battery family violence arrest. Not sure of the disposition. 2016 battery family violence out of DeKalb County. Simple battery family violence, disorderly conduct, simple assault family violence. Those were dismissed. 2012 theft by taking dismissed. And before that was a 90s simple battery conviction. That's it.
Thank you. Ms. Mitchell?
Yes, Your Honor. The state's bond recommendation is going to be a $5,000 cash bond, no further contact with the victim, Rachel Wright, Wright spelled W-R-I-G-H-T. Stay away from address 155 Parker Wood Way, Alpharetta, Georgia, and no alcohol, drugs, and weapons. Your Honor, in this case, on January 24th, the defendant received a criminal trespass warning by Alpharetta Police from Ms. Wright's property on the 155 Parker Wood Way address. The next day, on January 25th, the defendant was back at Ms. Wright's property on her front porch. Your Honor, the state has some serious concerns in this case. Although this is the defendant's first criminal trespass, he has a very violent criminal history, including 3 convictions of simple battery and 1 conviction on a charge I won't sound for at this time. Additionally, the defendant has several cases with this same victim, Ms. Wright. She currently has a TPO on him this year, an aggravated stalking and damage to property case 2017, a TPO in 2017, simple battery family violence 2017, a battery family violence, simple battery family violence, simple assault family violence, and disorderly conduct 2016, a theft by taking 2012, and a couple other civil cases. Again, this is these cases are all with the same victim. The defendant also pled guilty under the First Offender Act in aggravated stalking against Miss Wright in 2017, where the sentence was 3 years, served 6 months, and balance probated 2 years, 6 months. And that ended in 2020. In the 2017 battery family violence case against Miss Wright, the bond on that case was set at $5,000 surety. The state has serious concerns of defendants' intimidation of this witness. There's high risk of intimidation here, and the defendant is a huge danger to Miss Wright. Miss Wright is very scared. She told our victim advocate she fears for her life and believes that if the defendant is released, that he will come back to her home and harm her. Miss Wright also stated that the defendant told her, quote, "I will kill you and then kill myself because I'm not going back to jail," end quote. If the defendant continues to come back, we are concerned that one of them, if not both, will get hurt. And the last thing we want to do is put Miss Wright in a situation where she feels the need to take matters into her own hands. Miss Wright filed and received a TPO in 2017 as stated, but she also filed one today. She had the hearing with the judge at 12 and it was granted, so she can now serve him while he is in jail. Your Honor, Miss Wright is on the Zoom with us today, so Your Honor may sound for her at this time or after the defendant's case. Nothing.
I'm gonna hear from Ms. McLeod first, then I'll sound for Ms. Wright. Ms. McLeod?
Yes, Your Honor, I have spoken with my client. He has been living in the Atlanta metro area for about 30 years. The lady who is the alleged victim has had a very long-standing relationship with my client. And while it may have been, they may have had their issues from time to time, she has willingly invited him into her home and into her life over and over again. Even though she's saying now that she fears him, and there was a time when she alleged that he was stalking her, she has provided him with her address, her telephone number, and has continued to have contact with him. When she's unhappy with him, then she says, you know, I don't want you around. While it may not be the healthiest of relationship, it is one that she continues to support. And then when it suits her, she feeds into the judicial system to keep him at bay when it's convenient to her, or when she's a little tired of him, and then she calls him back, and it's just been continuing to happen. I think it might be a good idea for them not to have any contact, but I don't think it is necessary for him to have a surety bond. He is gainfully employed, he tells me. He does not live with the defendant. He with the alleged victim. He lives in Tucker. She lives in Alpharetta. There really is no reason why she should be in contact with him. And since, as the state has stated, she now has a temporary protective order, we see no reason for the defendant to be kept in jail when he can just go along with the court's order to stay away from her. Based on that, Your Honor, we would request that he be given a signature bond or a very low bond, certainly not a cash bond, because he doesn't have the resources to post a cash bond at this time, Your Honor.
Thank you.
And
At this time, I'm gonna sound, Ms. Mitchell, one moment, I'm gonna sound for Ms. Wright and then give both parties an opportunity to respond. Ms. Wright, if you would like to make a statement today here in court, I need you to turn on your camera and unmute your screen. Do you wish to make a statement today?
Yes.
You're not required to do so. Okay, you do wish to make a statement. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes.
All right, Ms. Wright, what would you like to tell the court today?
Not only Mr. Snipe has been following me in the car, I just want to make it sure I don't want him around me, period. It's no, me and him in no relationship or anything. I just need him to stay away from my daycare and anywhere I go. That's why I did put a TPO order on him.
All right.
And stop calling me.
Thank you, Ms. Wright. I appreciate that. All right. Would either party like to make any further argument before I make my decision?
Yes, Your Honor.
Yes.
Okay. All right, Ms.
I would
Mitchell.
just like to point out that she has not stated that she is afraid of him or anything like that. She just wants him not to call her. And I think that's a condition that he certainly could abide by, and to stay away from her and her daycare. I think she's stated very clearly what her concerns are, Your Honor.
Thank you. Ms. Mitchell.
Yes, Your Honor, just to reiterate to the court, the defendant has had 6 other cases with this same victim, Miss Wright. Miss Wright has spoken with our victim advocate today and has made it very clear that she does fear for her life. And regardless of, as defense try to put it, Miss Wright's mood, it doesn't change the fact that this defendant has threatened to kill both of them, and has stated that to this victim.
Okay. I want to look up one thing very quickly. And then I'm going to make my decision. All right. Based upon the information that is before me at this time, Mr. Snipes is going to receive a $3,000 surety bond. He is to have no further contact with the victim, last name Wright. He must stay away from her address on Parkerwood Way. He is to have no weapons, drugs, or alcohol as a condition of this bond. And I forgot to mention this earlier, all those parties receiving a surety bond today will be reset to the SAP calendar on February the 8th of 2022, whereby bond and other issues can be revisited at that time. Are there any provisions that I have not addressed as part of this ruling?
No, Your Honor, thank you.
All right, best of luck to you, Mr. Snipes. We can move to the next position.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, have a great afternoon, Ms. McLeod.
Thank you, Your Honor.
Take care.
Position 11, Taylor.
Okay, good afternoon, Mr. Taylor. Your case is 22 CR 000355E, in which you're charged with simple battery with an offense date of June 29th of 2020. You've heard me advise of your constitutional right to remain silent and to an attorney. Do you object to a video hearing today?
No, I don't.
And do you object to your attorney, I believe it's Ms. Kim, assisting you from a remote location?
No, I don't.
Thank you. Mr. Howard?
25 total. Last arrest was on the 20th of this month for suspended registration. 2019 FTA, obstruction, driving while license suspended. 2018 battery conviction. 2018 probation violation. 2018 he had an arrest for possession of a firearm by convicted felon or felony first offender. 2017 convictions for the following: obstruction, misdemeanor, possession of cocaine with intent, possession of a firearm by convicted felon or felony first offender, possession of a firearm during the commission.
That's good, Mr. Howard. I have a clear picture. Thank you. Is it Ms. Duncan? Ms. Duncan, is this your case?
Yes, Your Honor, this is my case. Good afternoon.
Good afternoon. What is the state's recommendation?
The state's recommendation for bond is $3,000. Surety is stay away from the incident location, no further contact with the victim, no alcohol, drugs, or weapons, or a one-day anger awareness. The state is basing this recommendation on the defendant's extensive criminal history. In addition to what pretrial has stated, the defendant does have a simple battery family violence arrest from 2010. And the state, in this case, the defendant hit and pushed his sister who lives with him. Her name is Celeste Leverett. That's CELESTELEVERETT. And the state is particularly concerned about the violent nature of this offense due to the fact that this defendant has a history of issues with family or those whom with which he lives, in addition to the fact that the state has a concern that this defendant is a flight risk due to the previous FTAs that pretrial listed. And we have a concern about intimidation of the witness in this case as well, due to this defendant's violent history. This offense took place at 2429 Martin Luther King Jr. Drive Southwest at around 7:30 p.m. on June 29, 2020, as the as Your Honor has stated. However, we have tried to contact this victim. We have made an unsuccessful attempt, and until further notice, are going to prioritize the safety of this defendant and victim, my apologies, and request the bond and the conditions as stated.
Thank you. Ms. Kim.
Yes, Your Honor. First of all, my defendant clearly denies all allegations. There was money involved in this case. Basically, he won about $80,000 settlement award last year, and then he invested with his sister together to the business. And when he was requesting the money back to be returned to him, that's when his sister became vindictive to not to give the money back to him. That's the main reason that this came about later on as a method to kind of like make him to stay away from her. We do not object to stay away from order. However, we request for signature bond because even though it sounds really bad by saying 25 total, most of them happened before 2002, 20 years ago, or very long time ago. He has become different person. He has children. He's living with 18 years old daughter, and today is the birthday of his first daughter, 22 years old, Angel. That's her name. He's looking forward to go back and celebrate with her. Also, he does not have to go back to 24 Weatherly, that place where his sister is. So we are fine with the stay away order. And he has been living here in Georgia for all his life. His family is here, and he's been working really hard to get his life back together. And he started his business, rental car business, and he set up his own business, and he's looking forward to work really hard to accomplish his American dreams. However, things kind of became really difficult lately. And even though if your honor is not inclined to give signature bond, we request for lower bond, like maximum $500, because of his current situation, that most of his lump sum money has been taken away by the victim, Celeste, who is refusing to return any money. So we do need your consideration for that. That's it, Your Honor.
Thank you.
Your Honor, the state would just like to reiterate that not giving money back in relation to a settlement is not an adequate circumstance that would promote such violent and irrational reaction in this defendant. And according to my calculation, this defendant has had at least 9 convictions in the past 10 years. So given the facts stated by the defense and the state, we request a bond and conditions as stated.
Thank you, Ms. Duncan. At this time, Mr. Taylor is going to receive a $1,500 surety bond. He is to have no further contact with the victim, last name Leverett. He is to have no weapons, drugs, or alcohol, and he must stay away from that incident location on Martin Luther King Jr. Drive. All right. If there's nothing further from either party, best of luck to you, Mr. Taylor. We can move to the next position.
Position 12, Walker.
Okay, good afternoon, Mr. Walker. Your case is 22 CR 0000356E, in which you're charged with 1 count of possession of marijuana less than an ounce, 1 count of reckless conduct, and 1 count of obstruction of a law enforcement officer, each with offense dates of January the 25th of 2022. I want to advise you that you have an absolute right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney. And is it Ms. Kim, do you represent Mr. Walker?
Yes, Honor. Yes, Your Honor.
And as you can see, we're conducting this by video. Do you object to the video hearing?
No.
Thank you. Mr. Howard?
Fourth, let's see. two cycles got the same dates on them from 2019, February 26th. Out of DeKalb County, I got armed robbery, home invasion, first degree, felony theft by taking, ag assault, and felony obstruction. I think that's still open. Let's see. Actually, he has 3 cycles with the same date. So this would be his second adult arrest because his 2017 arrest was juvenile. So he just got an open case in the cab.
Thank you. Ms. Duncan, is this your case as well?
Yes, Your Honor, this is my case. Just to clarify what pretrial was stating, this defendant does have a burglary first degree from 2017. There is an aggravated assault and a willful obstruction from 2019. There's still no disposition, so it is assumed that the case is open. There's an additional case for armed robbery, home invasion, and theft by taking with an offense date of January 31st. 2019, and then there's an additional aggravated assault and willful obstruction felony that was dated February 1st. And in this incident, police were doing community surveillance and they encountered 2 individuals, one of which was the defendant, Jack Walker. And upon viewing these defendants, they were making a tactical stop because they believed that they saw one of the Mr. Walker with a firearm. Once they completed their tactical maneuver, Mr. Walker took off running and he gave chase for about 15 to 20 minutes. On his person, officers located a blunt with approximately 1 gram of marijuana. And while they were trying to detain him, again, he started running from the officers. He had a gun. He initially told officers that he threw the gun in the waterway behind a house where he did not live during the foot chase. And then he further admitted that he did not throw the gun in the waterway. However, he stashed the gun in the bushes while the officers were preparing for their tactical maneuver. And as pretrial has stated, and I have confirmed, the defendant does likely have open cases that involve weapons, and it is unlikely that those cases do not involve a no weapons provision. So he is violating that aspect of those cases as well as this one, in addition to continuing to have a weapon. And it's for those reasons that the state is requesting a $6,000 surety bond based on the history and the facts presented. That's $4,500 for the reckless conduct, $1,000 for the obstruction, and $1,000 for the marijuana. And we're requesting that those be surety with the additional condition of no alcohol, drugs, or weapons at this time, Your Honor.
Can you give me that breakdown again, Ms. Duncan? You were asking for $4,500 on the reckless conduct?
Yes, $1,000 on the obstruction and $1,000 on the marijuana, all surety, $6,000 total.
Okay, Ms. Kim?
Yes, Your Honor. Please, considering the fact that he's only 20 years old and he is trying to get his life together with studying up his GED to get his high school degree. He is not employed at this point, so having $6,000 bond is very, very challenging for him to do. We do understand that he has to stay away. Older. We do not object that, and however, it will be great to have a little bit lower bond amount of maybe $300, reasonably surety bond. And right now he's living in Stone Mountain, Georgia, and he's living with his grandfather. And I mean, this is something that he is aware of, and he's trying to get better as a young man. Yes, that's it, Your Honor.
Thank you. One point of clarification, what was the stay away address, Ms. Duncan?
We were not requesting a stay away as this encounter and chase took place on the street. It took place, however, around the address of 1735 Joseph Boone Drive, but we are not clear that that is where he lives. We just have the facts that that's where the chase and encounter took place.
Okay, thank you.
And the state,
Go ahead, Ms. Duncan.
and the state would
Very
just
briefly, very
like-
briefly.
The
Go
state
ahead.
would just like to reiterate, he does have a history with weapons offenses and obstruction, so. we
Yes,
would like
that's
to-
clear. Thank you. I got that very well. Thank you very much. I appreciate that. At this time, Mr. Walker is going to receive a $500 surety bond for the possession of the marijuana, a $1,500 surety bond for the reckless conduct, and a $1,000 surety bond on the obstruction charge. That should equal a total of a $3,000 surety bond. He is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party?
No, Your
Nothing
Honor.
further.
Thank you. Best of luck to you, Mr. Walker. Who do we have next?
Position 13. Right?
Okay. Okay, good afternoon, Mr. Wright. Your case is 22 CR 00357C, in which you're charged with obstruction of a law enforcement officer with an offense date of November the 18th of 2021. You've heard me advise you of your right to an attorney and your right to remain silent. Do you object to the video today?
No, ma'am. Good day, everyone.
Thank you. Mr. Howard?
Well, I got 14 adult arrests, 2019 arrest out of Alabama for trafficking drugs, resisting arrest, carrying concealed weapon. I didn't see a disposition for that. Last arrest in Georgia was 2018 obstruction and disorderly conduct. Disorderly conduct was a conviction. Obstruction was dismissed. 2016 failure to appear for obstruction, not prosecuted, is the disposition. 2015 misdemeanor obstruction conviction. 2014 probation violation. Underlying charge, possession of marijuana. 2014, another 2014 probation violation, theft by taking. 2013 probation violation, failed to report. He got 5 probation violations in his history, 1 FTA. 2011 disorderly conduct, pled nolo.
Thank you. Ms. Duncan?
Yes, Your Honor. This incident took place on November 18th, 2021. The address stated on the warrant was 960 Welch Street Southeast. In this case, Your Honor, it also appears that this defendant, according to GCIC, is wanted for failure to appear from October 2019 as well. And in this case in particular, a neighbor reported to authorities that the defendant's dogs, 3 dogs at least, were pit bull mixes, were running around at large. The defendant in this case refused to sign the citation given for the offense, and the defendant did not give violence toward the officer at that time. The state would just like the court to know that this defendant has been cited at least 15 times for violations in relation to the dogs. His history makes it clear that he's shown a refusal to submit to legal authority and obstructing the police. And because of his arrest history and the probation violation history, the state is requesting a bond in the amount of 1,500 surety. And with the conditions that this bond be revoked if the dogs are loose again and it is reported, in addition to the fact that we would like it to be that Mr. Wright cannot purchase or shelter any additional animals other than the ones already in his possession as of today until further notice, and no alcohol, drugs, or weapons.
All right, thank you, Ms. Kim.
Your Honor, Mr. Wright, actually, this is about dogs that he claims that he does not own. He's basically whatever dog does has nothing to do with Mr. Wright. And however, because of the past histories of convictions, it seems like he has prejudice against him for what he's, so to speak, not his dogs, whatever they do. The neighbors reported on November 2021 about the dogs that he clearly told the police that he does not own them. And also, just because he didn't sign the citation, I mean, that's the reason that he got arrested here. And there's no reason for him to open the door. If you read the affidavit for arrest, he was arrested not only because he did not sign the citation, but because he refused to open the door. And he has no reason to open the door. This is his place, and if he does not want to open the door, that is fine. And he told the officer they could leave the citation at the mailbox, and I think that should have been sufficient. He has been here in Georgia more than 20 years, and he's married. He's not married, however, he has one child, and he's expecting a boy this coming April 2022. He's becoming a really good father, and he has been missing a work because of this arrest. He has been working as a stage hand. He basically makes the stage for the movies or play. He is facing the fines for missing those work days. So having too high bonds is not really good for him right now. So we request that the bond will be set probably maximum up to $1,000. That's it, Your Honor.
Thank you. At this time, Mr. Wright is going to receive a $750 surety bond. He is to have no weapons, drugs, or alcohol as a condition of this bond. And I believe those are the only restrictions I'm going to impose at this time. All right.
Thank you, Your Honor.
Anything further from either party as it pertains to this case? If not, best of luck to you, Mr. Wright. And I believe we've concluded the entire calendar.
Your Honor.
Yes, Ms. Gantz.
I do apologize for interrupting. I received an update on Mr. Fernandez. And if we can hear him today, I'm prepared. If we can reset then tomorrow.
Is he not in quarantine? Or have you, you're gonna waive his appearance?
Yes, and I just submitted that form, Your Honor.
Okay. All right, we can go to position 4, Mr. Fernandez, who's charged with loitering and prowling. Mr. Howard, can I have Mr. Fernandez's history?
I already put it up. I gotta go get it. Unless you want to go off the states. I think it's
we'll go with the state, and if there's any confusion or discrepancy, we'll come back to you. Mr.
It's the
Long?
first arrest though, I think.
The state doesn't have any history either.
Okay. All right.
Let me go get it. Are you saying it's a first arrest or you don't have it out at all?
As far as I know, it's first arrest.
Okay, I think that's what I had to.
All right, Mr. Long, the state's position.
Yes, Your Honor. The bond is currently at $1,000 surety. We're asking that it remain as currently set with a stay away from 339 Camden Road, Atlanta 30309. No further contact with Mary Cohen. Cohen is Cohen. This is from January 8th of this year, and the police were dispatched on a prowler call. The defendant was found standing next to a car looking at the home with 339 Camden Road. The defendant spoke Spanish. The screen door was found open, and a Spanish-speaking officer responded, and the defendant told the officer that his friend lived at this location, but contact was made with the owner, Mrs. Cohen, who stated she did not know the defendant, was not in town, and was awakened by a Ring doorbell alert on her door. She noticed that the defendant had been attempting to gain entry to her home and called 911. The defendant was observed pulling on the door, but did not gain entry. So we're asking for the bond to remain as set because the case reads like a potential burglary, considering it was 2:23 a.m. as stated on the warrant, and the defendant was repeatedly attempting to gain entry via the locked door. So for that reason, we're asking for the $1,000 surety to remain. Thank you.
Thank you, Ms. Gant.
All right, thank you, Your Honor. At this time, Your Honor, we are unopposed to the $1,000 surety bond. We ask that Mr. Fernandez be reset to the SAP calendar, February 8th, 2022, which he will be reset anyway if he gets that bond. And Your Honor, we are the defense is prepared to submit an order for the court's consideration, specifically an MHET order at this time. And we are opposed to the conditions regarding the stay away and no further contact.
Okay. At this time, I am going to adopt the state's recommendation and I will consider the order. Ms. Gant, I may have some, actually, can I be put in a breakout very quickly with Ms. Gant? I have some questions about the MH. If Mr. Long would like to join that breakout as well, I have no objection. If we could
Yes.
be
So
put
we
in
just want
breakout
you,
really quickly.
you, Judge Gant, and Mr. Long.
And Ms.
Yes.
Falk as well, if possible.
Oh, I
Oh,
missed
Ms. Falk. Okay,
very quickly.
okay.
All right, based upon the information before me, the defendant is going to receive $1,000 surety bond. I am going to enforce that stay away. He must stay away from that address on Camden Road. He is to have no further contact with the victim, last name Cohen. I am going to sign the requested order from the defense. And I believe I've addressed all provisions here. He is to have no weapons, drugs, or alcohol as well as a condition of his bond. Is there anything further from either party?
No, Your Honor, thank you.
All right. All right. Please tell Mr. Fernandez best of luck to him. Ms. Gant, can we review the calendar, please, Ms. Middlebrooks?
Yes, I am ready.
Position number 1 is a $4,000 sign-on bond through pretrial. Reset further notice. Position number 2, a $3,000 sign-on bond. Judge, is that jail or pretrial?
That's jail.
I'm sorry, what position, Ms. Middlebrooks?
Position 2.
Through the jail.
Through the jail, okay. It'll be reset further notice. Position number 3 is a $3,000 sign-on bond through pretrial. Position number 4 is a $1,000 good bond, reset SAP February 8th. Position number 5 is a $2,500 sign-on bond through the jail. He'll be reset to the SAP February 8th, 2022. Position number 6 is a $4,000 good bond, reset SAP February 8th, 2022. Position number 7 will be reset to the C calendar for tomorrow, January 27th. Position number 8 is a $10,000 good bond, reset SAP February 8th. Position number 9 is a $3,000 sign-on bond through pretrial, reset further notice. Position number 10 is a $3,000 good bond, reset SAP February 8th. Position 11 is a $1,500 good bond, reset SAP February 8th. Position number 12 is a $3,000 good bond, reset SAP February 8th. Position number 13 is a $750 good bond, reset SAP February 8th. And the add-on calendar is a $3,000 sign-on bond through pretrial, reset further notice.
Excuse me, may I know position 1, whether that SOB is through the jail or pretrial?
Pretrial.
Thank you.
Any comments, questions, changes, or corrections at this time? All right, hearing none, we'll be in recess until tomorrow, Thursday, January the 27th at 2 p.m. Everyone have a great afternoon. Take care.